Mr. Batiste, in clause number 24, DCCR 0407, charged with the state jail felony offense, possession of marijuana, from October 14th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment will be between 6 months and up to 2 years in prison. Do you understand? So, again, in 24 DCCR 0917 and 0918, you're charged in each of those cases with first-degree felony offense of murder from January 10th of 2024. The indictment in each of those cases alleges that you were previously convicted of robbery, a second-degree felony, October 26th of 2018, and also unlawful possession of a firearm by a felon on that same date. And what that means in those two cases is that if you go to trial and you're found guilty, the range of punishment would be enhanced. The minimum punishment would be 15 years in prison to 99 years or life in prison. Do you understand?
Notice how carefully the judge is spelling this out. In criminal law, defendants must fully grasp their punishment ranges. Why? Because later on, nobody can claim, "Oh, I didn't know what I was facing." Smart move by the court.
And then in all three of those cases, I have here on the computer some documents, plea bargain rejections that you've signed with Mr. Gersh that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And it looks like the agreement would be for a 45-year term in the institutional division of the Texas Department of Corrections in the two murder cases, and I guess a 2-year term in that state jail felony that would run concurrently. All of them run at the same time. Do you understand the possible consequences if you go to trial and what your options are if you wanted to enter pleas of guilty? And do you want...
Here's the cliffhanger moment. The state offered him a 45-year plea deal. Sounds insane, right? But with 2 murder cases, that's actually a bargain compared to risking life. Question for you, if you were in his shoes, would you roll the dice on trial or lock in the 45 years?
I reject those offers and have all of your cases for trial. Okay, we'll get those cases set for trial. Obviously, if there are any pre-trial issues or legal things that we need to take care of prior to
clarify,
okay. Okay, the conviction was from the scene. True. Right. Okay, so you want to reject those offers and have all of your cases in trial, is that correct? Okay, then we'll get it set on the trial docket. Obviously, if there are any legal issues that we need to take care of ahead of time, get whatever you need to filed so that we can take those up prior to any trial date. That way there's no worries when we get to a trial if going forward or not. All right? I don't think that's a concern.
Consolidation. Translation. Both murder cases will be tried together. That's brutal for the defense because it doubles the impact on the jury. Think of it like Netflix dropping 2 shocking episodes at once instead of one. Way harder to digest without bias.
Okay, you've already filed it. Okay. Okay, sounds good then. All right, you may go back with the bailiff. Thank you. Good morning. Are you Tyron Henderson? And Mr. Henderson is on probation in 3 cases. In cause number 23 DCCR 0899, on probation for theft of property. In cause number 21-38934, on probation for evading arrest or detention with the use of a vehicle. And then in cause number 22-39131, on probation for unauthorized use of a vehicle. There have been motions to revoke filed in all 3 of these cases. Mr. Rennick has filed motions asking that I set bonds. Okay, so the theft of property is a straight probation. Other two are both before. So just by the nature of looking at the dates, without getting too far into this, it appears that he was on probation for evading and unauthorized use, and then received another probation while he was on parole for the theft of property. Is that correct? And those other ones were continued after that violation. And there are no bonds set at this time. Mr. Smith, I'll get to you, Mr. Rennick, quick, but what is the state's position of bond?
The only concern I had though is the on probation or to back however
So in those motions, allegations are one, a new arrest for evading arrest and detention with a vehicle, an arrest for reckless driving, both of those from March 23rd, 2025, failure to provide verification of community service, out past curfew at 3:35 a.m., behind and restitution. All right, do you want to call your client? Okay. I'm not worried about classes or hours. I'm worried about the fact that you're still getting arrested for the same thing that you're on probation for. And you've already been put on probation and given opportunity. You violated the law. You got another opportunity, and I continued you, and now there's some more violations. Based on those, and I'm taking judicial notice of the court's file, includes the motions, the administrative hearings. At this time, I feel that it is, especially with the nature of the offense alleged in what he's on probation for, with an evading with a vehicle, which is dangerous.
The judge isn't sugarcoating it. Evading with a vehicle isn't just running away, it's playing with lives. This is where courtroom reality slaps hard. Public safety trumps second chances.
You could hurt somebody. You could kill somebody. You have officers out there. Anyway, I'm going to find that it is in the best interest of the community that there be no bonds in any of your cases. We will set these for whatever y'all want to on an announcement. If it's really not true, we can have a hearing first on the motions and then move forward on the trial later. Okay, sounds good. We'll do a normal reset at this time. If something happens prior to that, just let me know. We can always figure that out. You can go back. All right, sir, are you Lantavius Strickland? And Mr. Strickland, you were previously in court, entered pleas of guilty to evading arrest or detention with the use of a motor vehicle, as well as unauthorized use of a motor vehicle. I've received the pre-sentence report and reviewed that. Has everyone had an opportunity to review that? Are there any additions or corrections? In addition to that, I have reviewed your jail incident reports. Everyone's been given a copy of those as well. Y'all both had an opportunity to review them. Or fight. You like to fight, don't you? You don't? You don't. Okay. I can tell you that I have people in front of me all the time. They're not doing what you're doing. Constantly fighting. And the way these reads, it does not necessarily show that you weren't the aggressor. It doesn't show either way on some of them, but it looks like these were some pretty mutual things going on. Typically finding places to fight, getting in the bathroom to fight so you can't be caught, and all that kind of stuff. How old are you? 19 years old. So here is where I am on this. I understand that you guys had agreed to the 180 days front. I don't know that jail necessarily is as useful as potentially something like ISF to track because of its age, nature of the offenses, and what's going on in jail. The only way I'm going to go along with this agreement is to try to get you in a better place to make better decisions so that you can be successful on these probations. I want you to be successful. We all do. But at the rate you're going,
This is powerful. Instead of hammering down with just punishment, the judge pivots to rehabilitation. Enter the ISF cognitive program, basically jail meets therapy boot camp. Goal: rewire decision-making before it's too late.
The conditions of your probation are always up to you. So I can give you what I want as a condition, anything that makes me feel like it would be helpful for you, helpful for me. So what I'm going to do at this time is find that you previously entered your pleas of guilty freely and voluntarily. And cause number 24 DCCR 2440 find sufficient evidence to find you guilty, and at this time follow your agreement and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison. Probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25 DCCR 0209 find sufficient evidence to find you guilty, and at this time follow the agreement, find you guilty of unauthorized use of a vehicle, sentence you to 2 years in the state jail prison. Probate that. You'll be on probation for 5 years in that case. I don't have a fine. Is there no fine in that one? The 1,000 and the others probably. Okay. Okay. So in each of these cases, you're ordered to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter complete the cognitive track of the ISF program. It's a 90-day program. It's in custody. You'll be transported from our jail to there fairly quickly. It's all about making better choices. Okay, so it's just to give you the tools you need so that you can be successful on this probation and not end up back in here and then go into prison. Do you understand? If you get in trouble now that you're on probation, you get in trouble in the jail, get in a fight, you get in trouble at ISF, and you don't successfully complete it, you're going to already be in violation of your probation before you ever get out. So you need to figure out how to just stick to yourself, follow the rules, do what you're supposed to do so that you can get out and not go. Okay? Alright, I'm handing you, and if you do everything you're supposed to, then for all practical purposes, your case here in court's over. You're going to serve those sentences while you're out on probation. But if you violate any condition of those probations, you'll be back in here, and you'll be looking at the 10-year sentence and the 2-year sentence that you already agreed to. Do you understand? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Okay? Good luck to you, sir. Take advantage of this opportunity. And go back with your bailiff.